Get ready, and here we go. Hello, and welcome to the American Museum of Tort Law, our video series with interesting speakers, thought leaders, lawyers, scholars, and practitioners. I'm your host, Rick Newman, and our guest today is attorney Robin Greenwald, here to talk about an important case with implications for people's health following environmental catastrophes. Robin is an attorney with Weitz Luxenberg, where she heads the Weitz Luxenberg Environmental Toxic Torts and Consumer Protection Litigation Group. She has taught environmental law at Rutgers University School of Law and was director of that school's environmental law clinic. From 2001 to 2003, she served as executive director of the international nonprofit water conservation organization, Waterkeeper Alliance, and she is also on the board of Public Justice. Here's how she describes her goals as an environmental lawyer. This is a quote. "My underlying goal in environmental litigation is protecting the environment and obtaining relief for the people who become sick or whose property is damaged because of industry pollution that could and should have been avoided." And that's just what she has done in an important recent case. Welcome, Robin Greenwald.
Hi, Rick. How are you doing? Nice to see you.
Thank you. It's nice chatting with you. Robin was involved in a pair of cases that have the following name: Benoit versus St. Gobain Performance Plastics Corporation and Baker versus St. Gobain Performance Plastics. And so tell us about the cases. Well, before you do that, they're really the same case. The reason that we refer to the Baker case is that's where the work was done at the trial court level. Then on appeal, the appellate court started preferentially calling it Benoit. But when we talk about them, that's the case, the St. Gobain cases. So tell us what the genesis of these cases, what happened?
So they all come out of a pollution incident in a lovely village called Hoosick Falls, New York. It's maybe about 25 to 30 miles outside of Albany. And it's kind of in the Berkshire Hills. And in that town is a relatively small factory. If you drove by it, I don't even know if many people would notice it, but it's a fabric coating facility. And it started in 1986, owned by Honeywell, and then it was taken over by St. Gobain. And it was owned by St. Gobain at the time that what led to this litigation was disclosed. So they used a chemical called PFOA. It's pretty famous now. I think everybody knows about PFOA, also called Teflon, also called C8, and it's made originally by 3M and then by DuPont. And it has several components, several purposes. It's a chemical that's used to coat things like pans for nonstick purposes. And it's also used for fabric to keep it resistant from oil and water. So like Gore-Tex, for example, has PFOA in it. Mm-hmm. At least it used to. I don't know if it still does, but historically it did. So PFOA is extraordinarily persistent in the environment, and neither Honeywell nor St. Gobain took any precautions with its releases of the chemical. So it escaped from the smokestacks, and it escaped from bad practices in getting into the ground, then getting into the groundwater, and then, of course, getting into people's drinking water. So Hoosick Falls uses groundwater for drinking water. And so when there's pollution, what happens with these kind of chemicals is if it goes out of the smokestack, it turns into droplets, and then those droplets drop to the soil. And then when it rains, they go into the soil, and when it rains, it goes further down, and then it eventually gets to the water table. Same if you dump things in the back or you dump things in a landfill that isn't lined, same thing happens. It leaches out, it goes into the soil, it keeps going down with rainwater, and then it eventually gets into the groundwater. And when it gets into the groundwater, it moves along with the groundwater, and then it ends up in drinking water supplies. So probably starting in 1986, people in Hoosick Falls started drinking PFOA. Nobody knew, or I should say nobody but the defendants knew, that this was getting into the environment. And in about 2013, 2014, there was evidence, certainly the company realized that the PFOA was in municipal wells. And that sort of started the whole, what I would say, very slow disclosure to the public, extraordinarily slow. It took almost over a year for the public to learn that they had pollution in their drinking water. And the reason I think people
Wait, the
started.
company knew, and it was not for a year that they told the people in town that their well water or their drinking water was
Correct.
contaminated?
Correct. The company and the state knew before they told the public as well. And so, there was so a lot of these companies. There's another company not too far away in Petersburg, New York, that had a similar situation where they learned that their company well had pollution, it had PFOA in it, took care of that, but doesn't tell the community. This, unfortunately, is not uncommon, where they find out and they hope they can brush it under a rug. So people in Hoosick Falls, eventually it came out that their drinking water was contaminated with PFOA, and really high levels. So at around the same time, there's the Parkersburg, West Virginia case, the DuPont litigation that the C8 panel came out of, which was the panel of scientists that addressed the health implications of exposure to PFOA in drinking water in particular. That was public. And so PFOA was kind of at the forefront. There were a lot of articles being written about how dangerous it is. Some people say it persists in the environment for hundreds, if not thousands of years. It's kind of hard to wrap our head around that, but it just doesn't break down in the environment. So the people of Hoosick Falls learn about their water being contaminated. And then there's a lot of government action quickly. And the EPA and New York State DEC make a decision that people need to go on bottled water because the water isn't safe, and they have to put in systems to make sure they can remove PFOA before people drink it.
Okay.
Of course, that's...
Yeah, what makes PFOA bad? Why is it dangerous? It
causes several serious diseases, including certain cancers. So it is a very dangerous chemical. And EPA has put a health advisory into effect in 2016, I believe it was, of 70 parts per trillion of PFOA.
Per trillion?
I'm sorry, gosh, 70 parts per million. I'm sorry, 70 parts per million. My bad. I'm thinking of another chemical when I said that. And people in Hoosick Falls, well, first of all, the water was contaminated at multiple higher levels than that. So it depended if it was, I should step back and say one other thing. People in Hoosick Falls got their water one of two ways. Some people were hooked up to municipal water. And so those people were, once the public water system was put on a treatment system and removed PFOA, they no longer were drinking PFOA contaminated water. But many people in Hoosick Falls are on private wells still. They're not hooked up to municipal water. So they had just wells drilled in their backyard. And so for those people, you have to put what's called a POET system, point of entry treatment system, on their homes because they have to get their water treated before people drink it. So it became a widespread problem. And they had been drinking it for so long, it really posed a pretty serious public health concern. And so people in the community, the state set up a blood testing system for people in Hoosick Falls. And many, many people in Hoosick Falls had their blood tested. And their blood level was multiples of tens to hundreds to thousands times higher than the national average for PFOA.
So these people were contaminated.
Oh, without question. And they had actual blood levels to show that it had invaded their body. And so that's sort of the background, the fact background to how this litigation started. Needless to say, kind of blew up quickly. It's in our backyard. It's really close, right? Hoosick Falls is pretty close to New York City. We had looked at that chemical before, and we went up and did a couple of town hall meetings and really got to know the community very well. It's a lovely, lovely, lovely group of people and a wonderful community. And then we started this case, and we work on this case. So I don't want to take credit for this case because I'm only one part of a much bigger team. We also worked with Faraci Lang in Rochester. Steve Schwarz and Hadley Matarazzo, and then my colleague Jaxie Billsborough at Weitz Luxenberg. And so we had many meetings up there and worked and joined forces and brought this action against Honeywell and Saint-Gobain for the contamination. And it was later amended, although this was after the appeal, it was later amended to add the manufacturers 3M and DuPont. But you don't notice that in the opinion because that opinion, that argument was before DuPont and 3M were added as defendants.
Mm-hmm. Okay. So tell us what happened in the litigation.
Right. So I think this case is significant now for one most important reason for, I think, purposes of this webinar or this, I don't know what we call this.
Video.
The video. This case really clarified what medical monitoring is and can be in the state of New York. And that is important for, I would say, two reasons. One, for all New Yorkers. Defendants had tried to, I would say, improperly characterize a decision out of the appellate division, which is, the Court of Appeals in New York, which is in most states the Supreme Court, right? So our highest court is called the Court of Appeals. For people listening to this who didn't know that, they may be confused by that. So our highest court in New York decided a case called Coronia. And I'll tell you in a minute how they ended up with the Coronia case. And so that case was very limited in scope. But like any good defendant, you can spread it out, stretch it, push it all sorts of different ways when you want to. And so that was in 2013. And interestingly, the Court of Appeals got that case from the Second Circuit. It was a federal case that was in the district court, and then it went to the Second Circuit Court of Appeals. And because the question being asked in Coronia, the Second Circuit believed was a uniquely New York legal question that they shouldn't answer in the first instance. They certified that question to the Court of Appeals to answer that specific question so that they then knew how to handle the appeal before it in the Second Circuit. And if you read the Benoit case, for those of you who are interested in reading it, that's the genesis, and the Second Circuit decision in Benoit talks a lot about that and how it got there and why Coronia is not what the defendants say it is. And so in New York, because of Coronia, so Coronia was a class brought by smokers who wanted who brought a cause of action for medical monitoring, and that's really key. Cause of action for medical monitoring.
All right. Well, let's talk about what is medical monitoring. Tell us
okay.
about that.
So medical monitoring is in New York, it's an equitable remedy. So it's an element of damages that you can get if you have been exposed to a chemical that has the capacity to cause a latent injury, and a latent injury, the early detection of which would improve or potentially save your life. So for example, some courts have held, to give you an example, that exposure to asbestos doesn't qualify for medical monitoring because there's no cure. It's really pretty sad, right?
Yeah.
And so I don't agree with that, by the way. I just want to make it clear.
Mm-hmm.
But some courts have said medical monitoring is not appropriate for that because there's nothing you can do to prevent the spread or the development of that disease to make it worse. But if you think about most cancers, if you catch cancer early, you can treat it. And oftentimes a person can live a relatively normal life after that. If you catch heart disease early on and you actually monitor it and you treat people for it, you can then have a much longer, healthier, better life than if you wait until the point where your heart disease is so far advanced. Of course, same for cancer. And so medical monitoring is key. And it's particularly key in my view, and most people who I work with would agree with this on our side of the V, is you're talking about people who just live where they live. They had nothing to do with this pollution, nothing. They drank the water that came out of their tap. They breathed the air in the community where they lived. Their kids played in the soil in the hill down the road. How are they supposed to know that the local company dumped PCBs on that hill from their manufacturing plant, or PFOA was dumped into the ground or put down a floor drain in the facility. They don't know.
Mhm.
And so they are truly classic victims of corporate misdeeds.
Right.
And now they have something in their body, right? They have been breathing it, they've been drinking it, they've been eating it, they've had the droplets get in their mouths.
And
And
it's
they
measurable that's in their body.
it is measurable. It
Mhm.
is measurable. And so that's why medical monitoring is so important, because if you detect a disease early enough, then people can get treated. And so now in New York, because of this case, if you can show that you are, even though you're asymptomatic, you have no illness right now. That's really key. You do not have to have an illness, but you can show that you have a measurable toxin in your body. And if you can show you have that, even if you are now totally healthy, you're entitled to medical monitoring in the state of New York. That is considered a tort, for which you can now have the remedy of medical monitoring. But the cause of action, the underlying cause of action in New York, has to be personal injury
Mhm.
or property damage. And so you have to have an underlying tort in order to have the equitable remedy of of medical monitoring. And in Coronia, the case referred to the Court of Appeals, the plaintiffs in that case were asking for a cause of action for medical monitoring because of their exposure to cigarettes. And the court here does not say there's a cause of action for medical monitoring. The court, in our case, acknowledges that you have to have a personal injury, but that it's okay, that's sufficient, that if your personal injury is showing that there is a measurable or an ability to measure a toxin in your body, that constitutes a personal injury. And the only other thing I'd say, and then I'll let you ask me questions, is the way it's been characterized by defendants is unless you actually are symptomatic, you can't have medical monitoring, which, if you ask me, makes no sense.
Right.
If you're symptomatic, then you're already on your way.
Yeah,
And the whole
that's
point of
safe.
this is early detection. And so often you don't really even know you're symptomatic, because you wouldn't know some of the signs that you can find out in medical monitoring, right? Just wouldn't
Right.
know.
Got it. So medical monitoring is really a shorthand, I guess, for the idea that the defendant has to pay to make sure that the plaintiffs, the families in whose it falls, get regular testing and examinations and treatment by physicians, even before they look sick or are sick.
Correct.
And so the question is, should they have to pay when there's no illness? And what makes this case significant is that you won because the mere fact that they have elevated levels of this poison in their bloodstream is an injury that
Correct.
entitles them to medical monitoring. So in other words, it lowers the threshold. You don't need to wait till someone is sick or at death's door or dying before they can be monitored. You can start it sort of proactively much earlier in time.
Correct.
That's an important decision, isn't it?
For people in New York, it's a critically important decision, because it had been misinterpreted after Coronia, quite frankly. But it's important across the country, because some states don't even recognize medical monitoring as an equitable remedy. I'm hoping that this case will reinvigorate people around the country to start to use the decision, I would say, somewhat wisely, because I think what's happened in the past, and I have not done a reading of every single medical monitoring case everywhere in the country, but I think that courts will still be a little wary of finding medical monitoring when you can't even show the presence of a toxin in the body. I don't think you have to have a test for every single person, by the way. I'm not suggesting that. But I think that in order for plaintiffs to grow this body of jurisprudence, it's really important, when you bring a medical monitoring case, to talk to an epidemiologist or a doctor or a healthcare provider and say, if my client was exposed over the past 5 years to this toxin in the air, what might be in his or her body that you could still test for, right? So some toxins you urinate out in 2 weeks. And so you're probably not going to find it in your body. You got to get it right away. So that's another thing. They could say to you, well, if it's been in the last 3 weeks, I can even test their urine, which is much less expensive, by the way, than testing blood, much less, like a fraction of the cost.
Right.
So I think there are ways. You don't have to spend, I mean, for in Hoosick Falls, it was paid for by the state. It would be very difficult for a plaintiff's law firm, I want to say candidly, to test 3,000 people for levels of PFOA in their blood. I mean, that would be an extraordinary obligation to take on.
Mhm.
And I'm not suggesting that anyone has to do that, but there's a couple of things plaintiffs could do. If you find out about a community like Hoosick Falls, you go to your state health department and you say, hey, in New York, they did this. And look what they found out. Something like 90% of the people have substantially elevated levels in their blood. Our people deserve the same. So people can use this decision, even with their politicians and their agencies, to get them to be proactive.
Mhm.
Or I would say you could maybe take the cross section of where you think people are contaminated, where you think the contamination was the highest, and you maybe do a sampling of, let's say there's a community of 100 people. I'm making up these numbers. Maybe if you test 6 or 7 people in different quadrants and you see they all have elevated levels, you go to the court and say, well, they're all within this zone of injury. And we know that these people in disparate places, different houses, have elevated levels between X and Y. I mean, there are ways you could do it without testing every single person. But I do think you have to have some evidence that the toxin is in the body, or someone who could say, again, an expert, who could say it would be impossible to live in this community and consume this chemical and not have that toxin in your body.
Right.
I think that would be sufficient, probably.
Let me just shift gears slightly and ask, I teach a course, and often my students believe that EPA tests all the chemicals that are out there in the world so that there's a log and a record and people aren't being exposed to environmental pollution. Is that right, or is that not so accurate?
So that is false. And I know that particularly because, I don't know if you know this, I spent 19 years working for the federal government. So an EPA was the agency with which I worked the most because I did environmental crimes. And so that was the agency with whom I worked and learned about the cases I was working on. So our system of government does not require any agency to test anything. It is all self-reporting. EPA sets the standard. EPA tells you how often you have to test, but 100% of that stuff is done by the company. So, for example, if you have a company that's allowed to discharge their waste into a water body, which is called Discharge Monitoring Report under the Clean Water Act, they have to give monthly reports of what they're discharging. Guess who tests that? 100% of the time, the company. EPA never tests. They may go out and look, maybe if they're doing a criminal investigation, they do, but as a matter of course, never. The air permits that require certain scrubbers and monitoring on discharges from smokestacks at corporations, at facilities, 100% tested by the companies. So, I don't know. And they also are the ones that report what's in their manufacturing process, if you think about it. EPA doesn't know, unless you tell EPA, that your manufacturing process includes PFOA. You have to tell them. And if you don't tell them, it's technically criminal because you have an obligation to do so. But does EPA go and knock on every door and figure out what they're making and how they're making it? Absolutely not. And I'm not even blaming EPA for that. I'll blame EPA for a lot, but I won't blame EPA for that. They don't have the resources. It's just not, our country's not designed for EPA to test what's coming out of any individual manufacturing plant.
So how are consumers, people in villages across the country, or cities or towns, supposed to know what they have been or are being exposed to?
Well, if you have a facility with a smokestack, an air emission, they have to report if it's a toxin under the toxic, it's called TRI, toxic, what does that stand for? TRI, toxic registry. I forgot what it's called. It's under the Clean Air Act. I'm drawing a blank on the acronym. And so that will tell you if what type of chemicals are coming out of the air into the air from that facility. Again, I told you about the discharge monitoring reports. I believe those are probably available on EPA's website or the state equivalent, because EPA has delegated some of those programs to the states. In fact, probably most of the states run the program now. So they could do that. If they believe there are improper discharges because of odor or people in the neighborhood having bad headaches or some other acute reactions that they had never had before, you have to go to your health officials. But I mean, the sad reality is you don't. I mean, I don't mean to sound negative, but you don't. And how many people in the community are going to know how to find TRI data? And even if you find it, how does anybody understand it? It's so complicated. It's like pages and pages of numbers, and it'll name a chemical and it'll give the parts per million or parts per trillion and how many on what hour intervals. And I mean, there's no way the average person understands that. Right. I don't know. I mean, it would be great if corporations had a much bigger hammer on their heads when they don't comply honestly, and honestly means no omissions. So often we only punish when someone affirmatively lies. Now, I don't really see a difference between an affirmative lie and an affirmative omission. It's the same thing, if you ask me. And so we oftentimes don't punish corporations for omissions.
Yeah. Well, so, I guess I'm wondering, why did it take a year then for Honeywell or St. Gobain or the state to tell the people in Hoosick Falls, oh, by the way, you're drinking contaminated water?
It's a great question. It's $1 million question we don't have the answer to. I guess it was wrong. They should have told them immediately. I guess their answer would be, well, you know, you have to confirm, you have to test, you have to have enough tests, you have to make sure the initial tests aren't false. You don't want to cause community fear if there's no reason to fear it. Those are all the answers they always give on the other side. I reject all of them. My view is you can always tell people, I have great news for you. We were wrong. Turned out it was only one well. It was contained. We're so sorry that we made you nervous. Isn't that better than hiding it from people? Mm-hmm. And then a year later, realizing for 1 year, I always think of this plaintiff in particular. The person who had a child after they realized they had contaminated the drinking water, okay? A brand new baby who they mixed their bottled formula with water from the tap with high levels of PFOA. Every child that 10 to 12 month period could have had 0 PFOA in their water if that company had been truthful. That's the only group that could have had 0, right? I want to be honest. Everyone else would have already had it, but they would have at least had a year less. Mm-hmm. That particular population of human beings, and the most vulnerable, I might add, they're infants, is the one that I always struggle with the most. Like, how can you not come forward the second you realize there's a problem? Again, you don't have to say, I'm 100% certain that your water is 100% contaminated and you're going to die. I'm not saying they do that, but I believe in full disclosure immediately upon reasonable belief that there's a problem. And you can contain messaging. People do it all the time. You can contain it. You can say, we're still testing. We're still determining the extent and the breadth of it. But then people can choose, right? We as citizens should have the right to choose and say, you know what? Until I know whether my water is clean or not, I'm going to buy bottled water. That's my choice to make. Right. It's not your choice to make me not know and have to potentially make my family sick.
Yeah. And then this was the same company that was opposing medical monitoring. That was the whole case. They didn't want to pay for medical monitoring.
Everyone opposes it. Every defendant opposes medical monitoring. And then the other argument they make is, well, there's no point in doing medical monitoring because participation rates are low. And so, okay, maybe participation rates in some programs are low. First of all, I do not believe that would be true in Hoosick Falls. I want to be completely 100% unequivocal about it. That community has been very active. Would there be 100% participation? Absolutely no. It never is. Never 100% of the people go and get their tests. But I will bet you anything that this would be a great case control study of participation in medical monitoring, because everybody knows they have PFOA in their blood. So I'm sorry. It goes to my phone. I forgot to turn my phone off. I'm sorry.
That's all right. So in any event, the good news is you guys won the case.
Correct.
And so the people of Hoosick Falls will be eligible for medical monitoring, even though they are not yet manifesting any physical signs of the illness, simply because they were exposed to and have elevated levels of this toxic chemical in their bloodstream.
Right. I want to just clarify one thing. So we didn't. They took this up on appeal, on an interlocutory appeal. So they made a motion to dismiss, saying we couldn't proceed on medical monitoring. And so the Court of Appeal said, no, district court was right. This is a perfectly valid legal theory. So we haven't won yet. Now we have to win our case, which I'm confident we will. So now we have to try our case because it hasn't been tried yet. So this was the dispositive motion to get our case dismissed. And so now we're proceeding along. We've been doing discovery all along, though, and we're very close. We've already filed our class certification motion. And so we're moving along quickly.
Good. Well, Robin, thank you very much for talking with me today. When the case is all wrapped up with a bow on it, let's do this again, and you can bring me up to date on the big finale. This is Attorney Robin Greenwald from Weitz Luxenberg, board member of public justice, who has been doing just tremendous work on behalf of people poisoned by industrial chemicals. Robin, thank you again very much.
Thank you very much. I enjoyed this. Thank you.
Okay, bye.
Bye.